when it all first started, it all kind of came up at an ad hoc place. First internet, then the email, then you have Facebook, then you have the other things. It was kind of a wild, wild west type situation where things were a little relaxed. And I remember a professor in law school was talking to me once about, it was a constitutional law class, and it was how technology goes faster than the law, and it takes the law time to catch up. Well, now in the time of social media, the law has caught up with the wild, wild west of social media, and you see lawsuits, you see regulations, you see guidelines all over the place telling us what the rules are in the world of social media. And so looking at the rules of social media, first thing I just wanted to look at how it has affected our population. You have the world population. The real world is just over 7 billion. That was as of yesterday, and the little ticker changes like every second. It increases, but it's over 7 billion. The virtual world, you can see Facebook has over 1 billion, YouTube has over 1 billion, LinkedIn, Instagram have huge populations as well. The virtual world is catching up with the real world. And when you're looking at the world of social media, these are some of the places that people visit or where they go to. And we're familiar with all of them. And I'm sure there are some that I have not mentioned that are out there. Jennifer probably knows several more. But there are several places to go. And now we're looking at, and I'm going to have Jennifer's input here, social media. When you look at that world, as an advertising pro, what do you see?
Well, from a branding perspective, I see a wonderful vehicle for building relationships with prospects and clients. I see a way to increase sales, to promote events. I see a way to humanize a company because social media is very personal by its very nature. So I see a lot of really, really good benefits to being in the social media space, which is why we recommend that all of our clients have some type of presence there.
And I want to formally introduce Jennifer Frazier. She's the president of the Creative Stable, which is an full-service advertising company that also focuses and helps clients with their social media management. And she is giving the talk with me today and giving some best practices on the social media management side. As we go forward, now when I look at social media, this is what I see. First, how do I protect my clients, their intellectual property, their interests? Where could they be potentially liable from lawsuits or from claims from other? And these are the whole list of things that I'm going through my checklist: copyrights, trade secrets, patents, defamation, privacy, employment laws, the different agencies, the Department of Labor, the EEOC, FINRA for financial agencies. The FTC has guidelines for advertising agencies. The Florida Bar has guidelines for us. It is regulated out there. And the one way that we now are using as a consumer, as a business owner, I ask you, when you see all this, what is it that you think of or that you see? It can get chaotic. And so today what we're trying to do is clear up the chaos. And we're going to do that by first work our way backwards. I'm going to give an overview of some of the legal principles, some of the legal theories out there. And then Jennifer is going to talk about some of the best practices now that we've had the legal principles in place. The two overriding concerns or concepts with the basic legal concepts with social media is, one, if it's illegal in the real world, it's going to be illegal in the virtual world. And two, if you're a business or employer, you are liable for the acts of your agents or employees if they're acting within the scope of their agency or employment. So if they're posting something on your behalf and it constitutes defamation from someone else or copyright infringement, they post something that infringes on another person's copyright in the name of your business, the lawsuit's coming against your business. And if you have a contractor that is working on your behalf, even though it's not employer-employee, under agency principles, that contractor's acts may render you liable as well. I just listed some of the legal side of the different concepts where it all comes in. The most common, or the thing that I think of first, are the intellectual property principles, because you think that's where people are putting creative works up there, whether it is written works, visual works, reposting, articles from someone else. So intellectual property is my first red alert, let's look at this. And so, when it comes to the intellectual property, there's a balancing act that I think business owners, employers, individuals have to do. One, with part of the advertising and promotion, you want to disseminate your information as widely as you can, or to your targeted audience, you want to get it out there while protecting your own intellectual property without infringing on another's, and as quickly as possible, because quite frankly, there's only so many hours of the day, and if you're spending hours and hours making sure you comply with everything, who's manning your business? So try to have those things set in the first place. An understanding of copyright. Not everything is protected by copyright. It is when a concept or original work of authorship is put in a tangible form of medium. It's not an idea, it's how you put the idea and you express the idea together. Facts by themselves are not protected under copyright law. How you express them or put them together may be protected under copyright law. Everyone I think knows novels, written stories, music videos, choreography. Those are pretty standard copyright. The main concept here is the ideas, facts, methods of operations themselves are not. And one also good thing to know, works of the federal government agencies, such as the photograph of the Earth that I put in my presentation, which came from NASA, are not protected by copyright. They're for us to use. They're our federal government, and it applies to all their agencies. That is not necessarily true with state agencies or state works. But if you're putting together a presentation and you're not sure and you want to get a statistic or something, if you get it from a federal government source or an agency, use it. It's there for you to use. Now, some misperceptions when it comes to using copyrights, when it comes to your post, your social blogging, or things of that nature, is it's out there in the public. That's my phone of all things. Okay. It's someone put it on the internet, so it must be okay to use. Because it's out there in the public, so it's in the public domain. No, that's not what public domain means. There is a concept of public domain under copyright law, but what it means is that something that maybe once was protected under copyright law is no longer part of that. It has no longer that protection. A copyright lasts usually the life of the author plus 70 years, or if it's a work made for hire or a work that's made under a pseudonym like a pen name, then it is 95 years from the date of publication or 120 years from the date of creation. Once that time period is over, it's in the public domain. Think of Shakespeare. Shakespeare plays are in the public domain. Fair use. That's another misperception that sometimes people think, well, I'm taking this person's article and I'm putting their name next to it and I'm using it and I'm repurposing it, and look, I'm doing this great thing, so that by itself is fair use. I'm being fair to them, so that's not copyright infringement. Well, not necessarily. Most instances, it probably could constitute copyright infringement. In fact, the courts use a 4-factor analysis in determining whether or not something is fair use. And that is, they look at the purpose and character of the use. They look at the nature of the copyrighted work, the amount and substance of what you're using, or using the whole part of the article or just a snippet of the article, and the effect upon the use on the market of the original author. So in this situation, one concept for fair use would be giving commentary, critique, education purposes. So if you have an article that you want to reference or part of it, you can reference part of the article, make a commentary about it, give credit to where credit is due. I would say this is the copyrighted work of so-and-so. Honestly, what I do, the extra caution that I do, I usually contact the source of it and see if I can get permission. Sometimes that's not practical. Sometimes it's a good business decision because it gives me an in to talk to someone else, and now I may have a new network or contact person. I did that on my website. I have a list of resources, and there are different agencies that I nonprofit agencies that I wanted to include and describe, having to do fighting elder abuse or things of that nature. I went and contacted them and said, I want to include your website in your description on my website. Is that okay to do so? And I built a relationship by doing it. So the main concept is, just because you're being nice and fair doesn't necessarily mean you fall within the fair use doctrine. And also keep in mind the fair use doctrine is a defense to infringement. So even if you think it's fair use, you're pretty certain you follow all those 4 categories, so you don't think it's worth it to get permission from the other person ahead of time, they may still file a lawsuit against you, and you still have to defend it, and you have to prove the fair use. So that's why when it makes business sense to do so, go ahead and get the permission. If it doesn't, because of time purposes or you're doing a whole lot of stuff, you want to assess the 4 factors. Trademarks and trade secrets, they also fall within the umbrella of intellectual property. Trademarks having to do with protection of your brand, logos, slogans that you may use. It can be a symbol, it can be a series of words. You have rights to that as well. Trade secrets is something, it could be a formula or a pattern, it's something that has independent economic value because it's a secret, because it's not widely known or publicly accessible, and you take reasonable efforts to maintain that secrecy. I want to take a second now to talk about the difference. Copyrights, trademarks, those are registered, you own them, they're public, so putting them in the public does not lose your rights to them. In fact, when you put them out there in the public, you want to put notice of your rights to ownership so that everyone knows this is mine. Because when you have those rights, it gives you the right to display the work, to sell the work, to copy the work, to make money off the work. Trade secrets, the very definition of it includes it being a secret. So that's something in your business that you don't want to post on the internet or anywhere on the social media. You don't want your employees to do it. You don't want the person who's posting on your behalf to do that. So you have to make sure in your workplace or in your business, you know what those are, and you take reasonable measures to secure their secrecy of it. Limit the access of who has access to this type of information. Best practices for intellectual property. I divided these in 2 sections. One, how to protect your intellectual property. Make sure you have confidentiality policies and practices in your workplace. I'm going to give a caveat that we're going to discuss this later on when I talk about employment laws, because it's not as simple as it sounds. Identify and restrict who can and how they can access your information or post your information. Know the terms of the terms of service for any webmaster that you use, or if you're posting on Facebook or LinkedIn. I have one on the next slide, I believe. I do. This is LinkedIn's term of use. You see the part highlighted. I just have to laugh at lawyers. This is just a paragraph of the term of use. It's actually several pages longer, and I'm laughing. I see all the words. We like words. But the part in red, you grant LinkedIn a non-exclusive, worldwide, perpetual, unlimited, assignable, sub-licensable, fully paid up, royalty-free right to use, to copy, to prepare any derivative works, to improve, distribute, commercialize in any way the information you upload on LinkedIn. So you still own it, but you give them permission to do what they want to do with it. So keep in mind when you post stuff on LinkedIn, and they're not alone. Facebook is the same way. I looked at Pinterest. It's pretty common. I even looked at some of the photo album things. You upload your photo albums to them. Most of them have similar language in there. So depending on the company, the federal government has had some limited success in negotiating the terms of use with these webmasters. Individuals and businesses tend not to. So just be aware of what it is. And then monitor the web. Monitor it to see, is anyone else copying your work? Has it been used in a way that you don't want it to? Because if you do see that, there are things that you can do to protect your intellectual property. You can send a cease and desist letter. You can send what's called a DMCA takedown letter, which basically is the Digital Millennium Copyright Act of 1996. And under that, there is a form that says, look, here's a procedure. You are improperly using my intellectual property. You have to give your information, why you think it is infringement, and that you request for them to take it down. And you can send this to the webmaster of the provider, whether it be Amazon, whether it be LinkedIn or Facebook, and they have to take it down. And if they don't, they can render themselves somewhat liable to do it if they fail to do so. So it's a very powerful mechanism. However, you can't just be willy-nilly about it and claim that you have ownership over things that you don't, because there's repercussions against you if you do that. One, that would be fraud, if nothing else. Okay. Going forward, now respecting the intellectual property of others. Don't just copy anything and everything out there. Be smart. Be smart how you do it. But really take a look at what is their IP to it. Do they have copyright on this? Do they have a notice? Some people have a notice. This is my copyright, but I give you permission to use it as long as you use it in its entirety. Then you know how you can use it. If you're using another's work, assess and follow the 4 factors that we discussed for fair use. Unless the work is in the public domain, and if you can, get permission from the person. Train your employees, your agents, anyone posting on your behalf on the social media policies and procedures on what and how to post different things, and that holds true also if you have a contractor doing this for you. So that's the overview of intellectual property. But we also have the real world of common law torts is now in the virtual world as well. One of my first cases in this matter was an internet defamation case. I represented a company that had made a big, successful in a business model of having indoor advertising in the bathrooms of restaurants or in bars. You go in there now, you start seeing advertising in there. They were one of the first companies to do this and was very successful in doing this. A competitor of them thought it was a great idea to set up a website that was very similar, if you did search terms, to the domain name of their website, and to say a whole bunch of false information, false facts against our client. Well, that ended up in a lawsuit, actually claims for defamation, unfair competition, and other acts as well. So if it's not, it happens. If it's illegal in the real world, it's illegal in the virtual world. These are some other types of common law claims as well. We were talking, Lauren and I were talking beforehand, how sometimes if you take someone else's name or likeness and you use it for your purpose, and if you satisfy some other elements, that may be another form of invasion of privacy type claim. So the best practices, again, prevent, monitor, influence, and protect with legal action if necessary. If you see that you're being defamed out there, protect it. You want to get it stopped. If you find that one of your employees or agents did something wrong, you need to stop that and you need to take corrective measures. And I know Jennifer is going to talk later on about when there has been a mistake and your company is in the public eye for doing something wrong, how you can handle that. So this would fall under that category. Oh, this is a funny case. I just put it in here. The real tool case. The court, let me read the court opinion first, and then we'll talk about the case. The court opinion had the judge saying, referring to, really defining on whether or not real tool is a term of fact or opinion. Referring to someone as a real tool falls into a category of pure opinion because the term real tool cannot be reasonably interpreted as stating a fact, and it cannot be proven true or false. So now that we know that a real tool will not be, calling someone real tool will not be defamation. That's a Minnesota case. I don't recommend testing it out in other states as well. It's not nice practice to do that. But the premise is on defamation. If something is pure opinion, it doesn't constitute as defamation. If you're saying a false fact and it causes injury to the other side and you incur damages, it can constitute, most likely does constitute defamation. This case, and this is, I'm sure if Jennifer was this physician's client, would advise him not to handle it this way. Or And he started posting things online. After the court opinion came down, the doctor posted online again saying he's going to file another lawsuit. And this was, the whole premise of this was the doctor treated a patient and the patient's son wasn't happy with the doctor's services and went online and called the doctor a real tool, which spawned this litigation. And then the doctor went online and said, you know what, I'm going to sue again. So not the best PR imagery. Oh, and then this is a famous case of 1-800-Flowers was a service where a husband came in and bought flowers, and the flower store sent a thank you card to his home saying, thank you for buying flowers. The husband bought the flowers for his mistress. The wife got the card. The husband and wife got divorced. The husband sued 1-800-Flowers under some privacy claims, and I think their terms of service or some contract claims as well. So you just have to be careful. That's a real world thing. I think the order was placed online, so that's where it kind of blended between virtual world and real world. But things are moving so quickly, and we're trying to do the nice thing. This is an example of sometimes we do need to pause and just think before we take any action. Profession, industries, and specific regulations. We talked about this a little bit before we started. They have caught up as well. If you're in any type of profession that's regulated in any way, I bet there are guidelines for you to follow on social media. Catherine and I, we're both lawyers. The Florida Bar has ours. The American Bar Association has guidelines on social media. Advertising, you have the FTC, and you have the Can Spam Act, which that's the one that you have to provide on mass emailings. You have to provide an opportunity for people to opt out. Mike, I know you're with the financial, so FINRA I actually printed up their regulations. They have a couple series of regulations for social media that are several pages long, as is the FTC guidelines is also several pages long as well. And the securities, SEC also has guidelines and regulations. And some of the overriding concerns that for all of these is we can't use social media to deceive people or to make any misleading statements. The SEC restrictions come in when SEC requires if you have a publicly traded company and they're about to go public or they're making a move, it has to be disseminated to as much people as possible, so it's considered public, it's not insider trading or privacy. So then the issue comes up when a CEO posts something on his Facebook page, oh, we were very successful in this merger today. Only his Facebook friends saw that. Does that violate the SEC because it's to a restricted group of people as opposed to the public? The FTC thought that it was a violation of it. Okay, so now we go into the Employers Act and their responsibilities in governing social media in the workplace. And it really is a tightrope because there are a series of laws that you want to comply with one, and it may bring you into liability for another. And just a caveat, once again, how preparing things for a presentation and using photographs. I'm looking for a photograph for this. I knew I wanted to find something on a tightrope thing, so I went to one of those stock images place. That for a small fee, I was able to download it, and they, in their terms of service, they had a acknowledgement saying we have rights to this copyright and we're able to give you the right to use it. However, we ask that you give this credit when you use this image. So the credit is below the photograph, and this is one of those ways, is the correct way on how to take an image from the website. Even if you think it was from a stock photo, or a stock photo image, you still have to look at their terms of service because there may be things that you have to do to comply with it. Anyways, moving forward with social media in the workplace. There are probably more laws than this that come into place, and in fact, I'm not going to say probably, I'm saying there are, but these are some of the key ones. The Stored Communications Decency Act, the Electronic Communications Decency Act, those come into play with, can you look at your employees' use of social media? Can you look at their emails? Do you have to give them notice? How do you do that? In the employment setting, you can look at your employees' emails, their internet use, but you have to give them notice of it. There are a couple elements that you have to establish, but the primary thing is you have to give them notice that you can do this. And if you follow the right steps, you're allowed to do that. the Fair Credit Reporting Act, the Genetic Information Non-Discrimination Act, Title VII, the National Labor Relations Act. Title VII is the federal discrimination statutes, FMLA, ADA retaliation. We're going to go through, I have this next slide, and by going through these issues, we're going to talk in to see how some of the laws come into place. And I probably will not talk about all of them. But you start looking at the hiring process. As an employer, should I look at an applicant's social media pages before I hire them as part of the hiring decision? How many of you guys think yes? And that was 2 there.
I think you should, but you shouldn't document the fact that you look at it.
Look but don't tell.
Yeah, look but don't tell. And the reason is, it is concerned, and there are 2 competing principles here. You can't make a hiring decision based on a protected class. And what if in going through their social media pages, you find that they are covered under the ADA? Maybe they are a recovering alcoholic that is seeking treatment. And they're talking about their recovery efforts and that they're in the middle of doing this. That puts them in protections of the American Disabilities Act. Now you decide not to hire them, and they find out that you looked at their webpage, you might get a claim that's saying the decision you decided not to hire them was because you found out that they were a recovering alcoholic. And you could do that example for a series of any of the protected classes out there. On the other hand, say you're hiring this person because you are a company that delivers things and you need to hire a truck driver. And you don't do that, you don't find out that he was an alcoholic, and you hire him, and sure enough, he's drinking on the job, gets into an accident, and injures someone. Now, the person that he was injured might claim that you were negligent in the hiring process because had you known this, you would have known that he was an alcoholic with a drinking problem, and you would not have hired him, and by doing so, led to you to hire him and for him to cause the accident. It's a little tenuous, but there have been claims like that out there. So that's where I wish I could tell you all the time, do it or don't do it, but it's not a bright line analysis like that. But the better practice to be would include having the set criteria of why you need or what you're hiring this person for. Have the skills, knowledge, and ability set down. Maybe line up and screen people first to see whether or not they meet those objective criteria. And then if you want to follow up on social media, you can. So this way, if someone doesn't meet that first initial blush of legitimate business reasons, you don't even have to look at their social media. And looking at the social media, there's also, do you tell the applicant that you're looking at the social media? Do you ask them? Do you give them permission, or do you not? You don't have to. One line of thought is you may want to be fully disclose what you're doing in the application process. Should you hire them, you're building trust, and you have to do relationship building. You have that type of good relationship from the start. On the other hand, you're giving them an opportunity to maybe change things, clean things up, and letting them know if you decide not to hire them later on, they're going to say you didn't hire them because you found something on the social media. My thought for me, I would not tell them that I'm going through the social media just for those reasons. And I would make sure that I really have the business reasons down, the skill set, the knowledge set, the ability set down on what I'm looking for. And if I'm not choosing someone, I will make a little notation or something that they don't qualify because of X. Okay. Should managers and supervisors friend employees on Facebook or LinkedIn? Let me say yes. Good. I'm glad everyone said no to that. It's a bad idea. That's going to bring in the harassment type claims. And then also it can bring in the discrimination claims as well, because what if the manager finds out something that would fall under a protected class? And now the same example that we talked about before, where the employee gets disciplined for something, they're going to say, oh, it's because the manager found out I'm qualified in this protected class, and that's why you're taking that action against me. So it's a bad idea. I'm just going to say no right off for that one. Should employees be allowed to comment or complain about the company on company social media pages? I have 2 no's. Well, that's also the tough one. Prior to 2011, I would agree with you guys outright, or probably prior to 2009. However, how I worded that question, it's too broad. Because the National Labor Relations Act protects an employee's interest to engage in concerted activity, which includes talking about the terms and conditions of their employment, which includes complaining about perhaps their wages, complaining about how they're feeling treated by their supervisor. That would be protected activity under the National Labor Relations Act. So if you just have a carte blanche policy, you're not allowed to comment about the company on social media pages, the NLRB is going to not look at that kindly. However, you can make it very clear, and you should make the distinction between speaking on behalf of the company and speaking about the company. Employers certainly can restrict who can speak about the company, what they can say when they're speaking about the company, because that's important to your company's reputation, to your branding, to your marketing. You want to make sure everyone's on the same page. Speaking about the company, you have to make sure you do not interfere with their protected rights under the National Labor Relations Act. So you can see, we can go through, should you have a social media policy? Yes or no. The reason why I say no, there's a different line of thought now between a couple different attorneys. Because of the National Labor Relations Act decisions of the past 2 years, a lot of people are saying, you know what, it's just not worth it anymore. What you think is a good policy, I'm getting fined for it because they think everything is interfering with the employee's rights. And if something can be reasonably construed to have a chilling effect on the employee thinking they can or cannot do protected activity, then it's a violation. So on that broad standard, the NLRB rendered a lot of policies under social media to violate the NLRA. However, if you don't have a social media policy in place, you are letting your employees go out there, and it's becoming more of a wild, wild west. So my recommendation is, and what I would do once I start having employees, would be to have a social media policy, but to double check, 1, the specific industry guidelines for my company, 2, the recent NLRB decisions, and re-look at your employment policies to make sure that they're not worded overly broad.
Isn't that insubordination though, if you go online and,
I know, you would
and say bad things about your
Yes,
boss?
you would think.
You would think so. There have been cases from the NLRB, which is National Labor Relations Board, where employees have gone on to complain about their supervisors, even called the supervisor a indecent word, and said that it had to do with their terms and conditions of employment, and therefore it was protected activity.
What benefit is it to them to go on social media and talk about this stuff? I mean, social media people can't help them.
Well,
So it's like it's the wrong forum.
part of the concerted activity is also talking with other employees, people of the press, and the public about stuff that terms and conditions in the workplace. And social media is considered to be a forum for that. There's a NLRB decision, it's a memorandum that came out last year, and I was looking over some of the policies that, first I'm like, this is a great policy. It protects confidentiality, it protects situations like that. Why would an employee be able to say mean things, I mean really indecent things about an employer?
Yeah.
And I thought for sure it was going to be lawful. I'm like, looks like something I could have drafted a few years ago. And it came up unlawful, 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 unlawful. And I have some examples we're going to go through later on, and where you can see part of that. But it's the NLRB's interpretation and enforcement of these types of things have just been broader in the last few years. That's why some employment law attorneys are telling people don't even have any policies. But you still have to protect your confidentiality, you still have to protect your IP, you still have to protect your brand, and you still want to have as much control as you can. So my recommendation is to have the policy, but make sure and be mindful of the NLRB decisions.
Now, what happens, Gary, in a case where if you have going back to somebody, saying something inappropriate about your company, that the company deems, and you hear about this in the news on a regular basis, where someone deems that statement is affecting the company's brand, because here it is, a supervisor or an employee is saying something very derogatory about the company in specific, which the company deems as negative publicity for the brand. You're saying they still can't just, depending on the state, of course, but terminate the employee.
This would be federal law, so the NLRA covers all of it. It is something that you'd have to actually look at the specific wording of what was said and look at it at prior decisions, because in some instances it could be wrong. But if they're complaining about something and part of the heated discussion or the heated complaint is, say, they're working long hours and that's what's creating their venomous attitude toward their employer, then that might say, well, they're complaining about not their working conditions, and that's what heated everything up, and so it's a violation. So there is no, unfortunately, a clear-cut, simple answer, but I would look at what was actually said, the legitimate business effect that it had on the business, and then is there arguably any concerted activity out there. Now, in some instances, the business decision may be to let that person go, even if there's a chance that you might get a claim of some sort later on. Because a bad employee, we may take this part out of the video, but a bad employee may, a bad employee may render more costs to to a business than having to defend a lawsuit or a charge. And if you take corrective action later on, that can also help you comply with the law in the future. So I'm not saying don't disregard the law or the National Labor Relations Act or any of those decisions. I'm saying if it's a really bad employee, you may want to, and it's causing turmoil effect and bringing down the business, still terminate them, do what you need to do to comply with the law in the future, and know that there may be a claim out there coming your way. And sometimes that is the better business decision to do.
Okay.
So, which is frustrating, as there have been so many times where I've represented employers and you get these things and it's frustrating. And you see a business owner or an employer really working hard to be fair with their employees, to comply with the law, and they get a claim out there. And the cost and the defense of it is so expensive that it does end up in a settlement. And it is frustrating that's part of how the system is, and it's very frustrating for business owners. Now, okay.
Kerry, the NLRA or the NLRB,
Yeah.
what number of employees do you have to have for it to apply to you?
No, it covers most all employees, all employers, so one employee. Now, there can be some industries are exempt from it, like common carriers and airlines, and those would be because they're covered under the National Railway Act. But for most instances, it covers most employers. Yeah. Okay, one quick thing on social media followers. This is now we're switching gears from the employment law. I guess, actually, before I switch gears, I just want to say, that's not all the issues that come up in the employment law context. Those are some of the bigger ones that come up more often, but because of the variety of laws that come into play, it is important for employers to look at their policies, look at their practices. When an instance comes up, a situation like that, that they don't just do a knee-jerk reaction, that they actually look and make sure that they comply with the law, make the best business decision with the options that they have available to them. This is having to do a little bit with business owners and employers and social media followers. Who owns, you hire an employee to do your Twitter, I don't use Twitter, to tweet for you, is that right? And they develop a following of 70,000 or more so followers. You fired that employee. Who owns the followers? They were doing it, you were paying them to do it, but the people were following them individually. There's not a, who
I would
thinks?
think it'd have to be the company that owns it. I mean, it's the same thing with the website or anything like that. It's the company that owns it, and you paid them for that service, so they forego their intellectual property rights. If I do an ad for Moffitt Cancer Center, they own it, I don't.
Yeah. I would agree with you. The law is not quite clear yet. The case settled, so there's not a legal analysis on it, but that's the legal arguments that I would make. And I would make sure when I hire that person, and the best way to clear anything up is to handle it on the outset. When you hire that person for this position, make it clear that you own it, you're paying them to do it, it covers under the work made for hire, and if for some reason that doesn't fit for this situation, they agree to assign it to you, to give it to you, to work with you so that you have it. And that's part of their employment relationship with you. Make sure you word it in such a way that you don't create you don't want to interfere with the employment at will nature, which you can do that, but you want to make sure that you contract it. Put it in writing, everyone knows, so you don't deal with this after the fact. Oh, the LinkedIn example, I'm going different ways. This is an interesting example. This is what I would not say would be a model employer. And this was an upper level, either manager or supervisor, I can't remember if it was an executive, let's just say upper management. Person was let go. Before she was let go, she had her assistant, had all her passwords to her LinkedIn pages and would do updates for her and things of that. So when she let go, the company still had her passwords. They kind of hijacked it from her, and they changed all the information so it was her replacement, but if anyone went on LinkedIn and did a search by her name, they got the new LinkedIn page with her replacement and didn't give any reference to her or where she went or anything like that. That ended up in a lawsuit as well, and it was settled as well. But the claims that the employee had was misappropriation of her information, inappropriately using her name, her likeness, and the company was probably going to argue that they hired her to do this, but the LinkedIn page, you know, that's a little gray. People write professional stuff on their LinkedIn pages, but they maintain it for their personal business as well. So the best practice is identify all these issues at the start of the employment relationship and put it in writing. Litigation in the courts, social media is coming into the courtroom as well. I had a friend who was trying a case, and the expert witness on the other side was discredited because of some postings that he put on his social media. It can be used in more and more as admissible evidence especially if it's something from the opposing party, then that would be admission by a party opponent, and it can probably overcome the hearsay objections. Juror use. An 8-week trial. This was a federal drug case, an 8-week trial. As a trial attorney, can you imagine spending 8 weeks in trial? That's 8 weeks of no sleep, of working very, very hard, and at the end of the 8th week, you find out that one of the jurors was researching the case on the internet the whole time of the trial. And when they were talking about it, the other juror said, "Oh yeah, I did that too." Well, jurors aren't supposed to talk about the case outside of the courtroom, and they mistried the case. So all of that was for nothing, and the case had to be tried again. Since it was a federal drug case, I'm sure the defendant was happy about that. That gave him a little bit more time, but I can't imagine the attorneys. And service by social media. Other countries have, so when you get sued, you have to have formal service of process in order for the lawsuit to go against you. You get a summons and a process, and you have to make sure that basically you know that you're being sued so that you can appear in court. Usually you have to go through you have a personal process server. There are some alternative ways to do this. In some countries, they're allowing people to be served by social media. Can you imagine checking your update post and someone saying, "By the way, you've been served"? The US doesn't have anything out there yet. I guess some legislature in Texas is trying to come up with a way to do this. I think it's a horrible idea because people can put up social media pages under false names. How do you really know you're getting the right defendant? I think it jeopardizes the whole due process part of having to have a summons and subpoena in the first place. So, is anyone interested in having online sweepstakes to generate interest? If you are, make sure that you don't inadvertently have an illegal lottery system. This basic, simple difference is a lottery is something where they pay an entry of a fee, a random selection of the winner, and a prize is awarded. A sweepstakes is different. You can have a drawing for a prize by chance alone with no entry fee, or if you're going to charge an entry fee, the prize should be selected or judged based on some skill or something like that. People get in trouble with regard to having illegal lotteries thinking that they're having sweepstakes. So if you ever have a business idea where you think it's a great thing to do, it probably is. Just make sure that you do it correctly and you follow the rules so you don't get in trouble. Okay, now here's the fun part. It's a game I call Are You Fine or Fined? Or it could also be called Process That. You'll see in a second. So I'm going to pass out cards. Make sure I get the right ones. I'm just going to go randomly. Would you like to pick a card?
Thank you.
Oh, and I'm going to, I want this one to be red too. And you can take this one. So when you go, I'm going to sit down for this. When you read your card, I'm going to ask, there should have a little number on the side of it. If you can tell me what the number is. And anyone want to go first, or I'm just going to start picking? Mike.
Okay.
What card do you have?
I am numberless.
Oh, can I see the card?
Oh, sure.
Oh, you have to go last.
Oh.
Sorry. Anyone else?
I'll go first.
Okay, what card do you
I
have?
have number 5.
Number 5. Okay.
Okay. I found a great article. I copied substantial portions of it in my newsletter. With a simple comment, great article. I sent this newsletter to all of my contents, uploaded on my website, blog, Facebook page, and LinkedIn page. I wanted to be fair to the author, so I gave author credit and provided a link to the author's website.
Congratulations, you get this document right here. You've been served with a complaint for copyright infringement. That's going through some of the things we discussed where it sounds fair, but there wasn't a lot of commentary on the article. It was just a great article. You didn't get permission to do that. And what if the person who, although you credit it, maybe the person who wrote the article didn't want to be associated with your website. So they were mad and they filed a complaint against you. You may try to defend it with a fair use defense, but welcome to the world of litigation. Okay. Anyone who wants to go next? Okay, what number are you?
Number 4.
Okay.
This photo is perfect. It's really worth 1,000 words. I'm going to include it in my presentation. I bet the audience will appreciate that I saved them from having to hear another 1,000 words from me. So I checked the source of the image. It is from a stock image site that requires a reasonable fee for downloading and requires that I source the original author. Done and done.
Very good. You get this document right here, a certificate of excellence in fine work.
Congratulations. Thank you so much.
Which one's this one? What number?
Number 6.
Okay.
Believe it or not, I wrote an ebook. I spent a lot of time on this ebook. I want to attract visitors to my website and enhance my reputation as a subject matter expert, both of which I hope to create new business. I do not want someone to take portions of this ebook out of context or copy or paste from it as intended to be read as a whole. So I uploaded it in PDF format, placed my name and contact information on each page, and place a copyright notice at the bottom of each page that looks like this. Copyright 2013, name, permission granted to download and copy in its entirety only.
You also get this document right here. Certificate of Excellence, fine job. And the key with that is the balance of wanting the information to be disseminated and spread, but you also want to protect the copyright of it. You may not want people to, depending on you may not want people to take portions of it out of context, so you require that if they're going to copy it, that they copy it in its entirety. Okay.
I can do number 7.
Number 7, yes. Okay.
I am a genius. I heard how testimonial reviews help businesses' reputation and drives business. So I instructed my social media administrator to comment about how great our products and services are on the company's Twitter account, Facebook page, LinkedIn pages, so on. Because we wanted it to look like a real customer, I instructed her to use her first name only. It is her real name, and she has used our products and services before, so we're fine. Here's how she did it.
Okay, pick one of these. Okay, let me see which one you picked. So on this one, what she did was just have the person's name. A little photograph says, shooting movie beach scene, had to lose 30 pounds in 6 weeks. Thanks, Fat Away Pills, for making it easy. The
I don't want one of those.
Sorry, the FTC doesn't like you. However, you got fined because you did not give notice that it was an advertisement, that it's a paid advertisement information that people need to know, and that all the results that you got are not the reasonable results that can be expected. However, if you chose this one, which the difference with this one, same name, but now it has the AD ad, a shooting movie beach scene, had to lose 30 pounds in 6 weeks. Thanks, Fat Away Pills, for making it easy. Typical loss, 1 pound per week. That, according to FTC, gets you a certificate of excellence of fine work. So you see the difference between the two? And then there was a third one I just want to say. This was the beginning one. And the beginning one, she didn't have any identifying information. Then you had the series of comments and talks, and then at the end, finally say, oh, by the way, I'm a paid spokesperson. The FTC found that was too far apart to do it, so it still violated the FTC, even though this one, the one at the top where it finally acknowledged she was a paid spokesperson, was good. It was just separated too far from the other ones. Okay, Jennifer, what number are you?
3. Knowing that the importance of protecting image online and being friendly while protecting confidential information, and certainly keeping any legal matters confidential, I decided to implement some policies for the employee handbook.
Okay. Which policy would you like to, you're going to work with some of your friends here. Which policy would you like?
I'll take this one.
And then you're going to read this one for her. And you're going to read parts of this one for her. You are now all the HR team working on the employee handbook project together.
Okay, so I read this.
Yes, and
Knowing it is important to be friendly online, you implemented the following. Adopt a friendly tone when engaging online. Don't pick fights. Social media is about conversations. When engaging with others online, adopt a warm and friendly tone that will encourage others to respond to your postings and join your conversation. Remember to communicate in a professional tone. This includes not only the obvious, no ethnic slurs, personal insults, obscenity, etc., but also proper consideration of privacy and topics that may be considered objectionable or inflammatory, such as politics and religion. Don't make any comments about employers, customers, suppliers, or competitors that might be considered defamatory.
who thinks that that's okay?
It sounds fine to me.
Is that a yes?
Yeah,
Mhm.
it's not.
Which is, this is when I was saying I was going through the policies, it sounded fine to me too. The FTC, or I'm sorry, the National Labor Relations Board said they found it unlawful for several reasons. One, the first warning for employees not to pick fights and to avoid topics that might be considered objectionable or inflammatory, such as politics and religion, and reminding employees to communicate in a professional tone. The overall thrust of this rule is to caution employees against online discussions that could become heated or controversial. Discussions about working conditions or unionism have the potential to become just as heated or controversial discussions about politics and religion. without further clarification of what is objectionable or inflammatory, employees would reasonably construe this rule to prohibit robust but protected discussions about working conditions of unionism.
Wow.
Yeah,
I would never have gone there.
No, me neither. Quite honestly, I would. Okay, the next one.
Legal matters. Don't comment on any legal matters, including pending litigation or disputes.
Okay, who thinks that's fine?
I mean, it sounds like a trick question, but it should be fine. That should be what they're supposed to do because of privilege.
I know, exactly, the attorney-client privilege. And once again, it's one of those things that I thought sounded fine by itself, the NLRB. And a lot of this is, you'll notice they say without clarification. We found that the prohibition on employees commenting on any legal matters is unlawful because it specifically restricts employees from discussing the protected subject of potential claims against the employer. Now, if you put it in the context of it could include complaining about unfair wages, then that is protected activity. So you do need to make sure that employees don't talk about attorney-client communications or privilege, but any rule just can't be worded so overly broad. Okay. This is a long one, so you can paraphrase it if you want or skip and paste it.
Communicating confidential information. You also need to protect confidential information when you communicate it. Here are some examples that you need to follow. Make sure someone needs to know. Never share confidential information with another team member. Let's say you need to know for a job. Develop a healthy suspicion. Don't let anyone trick you into disclosing confidential information. Watch what you say when in conversations regarding confidential information in the break room or any other open area. Unauthorized access to confidential information. If you believe that there may have been unauthorized access, or that confidential information has been misused, it is your responsibility to report that. We're serious about the appropriate use, storage, and communication of the confidential information. Violation of employer policies regarding confidential information will result in corrective action up to and including termination. It may also be subject to legal action, including criminal and medical prosecution. The company also reserves the right to take any other action it believes is appropriate.
That's protecting the company's confidential information, which we know is really important. And so who thinks that's okay? After going through these, it really pauses you to take a look at any of them. The NLRB found that that was unlawful in several respects, basically saying that it's overly broad. Some of the confidential information was overly broad in public places. Public places could include, the break room or other places in work that are protected places where employees are allowed to talk about different terms and conditions of the employment. Threatening employees with discharge or criminal prosecution for failing to report unauthorized access to or misuse of confidential information would be construed as requiring employees to report a breach of the rules governing the communication of confidential information set forth before. Because that rule itself was too broad and included some protected activity, disciplining them for it was also too broad. They did find the portion in the handbook that admonishes employees to develop a healthy suspicion and to report that was lawful, so it was fine. So overall, your HR team, Jennifer, did not do that well.
They didn't do well.
You guys got a NLRB
Oh, no.
charge.
not another one.
Yeah, sorry.
Again,
Okay. And Mike, you're the final one.
all right. Seeing what happened to the other company and all the NLRB ULP charges, I decided to review the NLRB's sample social media policy and my other policies such as confidential information and update my employee handbook.
He reviewed the NLRB decision. Here is the sample social media policy. And with that, Mike, you get a certificate of excellence. Fine job. And that is how we play the game, fine or fined. And I think it kind of the goal of it was to bring some of the concepts together and how some things aren't always as clear as they should be. And with that, Jennifer is going to talk about some basic best practices on how you can brand and market using social media.
Right. Well, here's the great dichotomy between social media for business. there's a little button on everything that says share. And as a marketer, I want you to share my information. I want you to share my clients' information. So we really do walk a very fine line because we want to build our likes on our pages. We want people to share our information. We want people to become aware of our brand and interact with it. But we have to do it in a way that's very, very safe. And one of the things to do is limit the number of administrators on any page. Some companies will just, they go in and whoever has time today that can log onto our accounts and maybe make some posts, you go ahead, Janie, you're today and Bob, you're tomorrow and whatever. Don't ever do that. Limit it to 1 or 2 people. Make sure that they understand what the corporate voice is going to be. And monitor. I mean, one of the things that we do for our clients, and this is just an example, this is for a realtor. So we have to be very careful with what they post on their social media. This is 1 month of Facebook posts, of blog posts, and it's all written out. Let me pass that around. It's all written out and improved in advance. So there's never a question on what day, what we're posting, how we're saying it, where the imagery came from. So we're covered on many different levels that way. Always make sure that cooler heads prevail. Never let a rogue employee or a disgruntled manager post something out of spite. This will correct that. This will make sure that there's either a cooling off period or the person who's got the administrative keys is not speaking off the script, so to speak. So again, make sure that you limit the number of people that have access to your page. If you hire an agency to handle your social media, make sure there's 1 person assigned to that account. Only 1.
Okay. And I just put a few legal comments in there. I'm not going to talk much about them because these are the issues that we already talked about. But making sure that the cooler heads prevail and having a policy against that, as some of the examples just said, make sure that you comply with the NLRA when you have those policies in place. And going to the next one.
Part of the beauty of social media is that it does allow companies to have a human brand. It puts a human face to a company. I think one of the companies that does it absolutely best is Target. Target will say really fun things like, who's in for some bocce ball? We call red. And here's a bocce ball set that's for sale this week. They have no problem poking fun at themselves, never at their customers, never at their products. But the whole voice and the whole tone is in keeping with the whole Target brand. It's very innovative, it's very now and contemporary and just a little bit edgy. So they do it really, really, really well. An example of someone who's not done it so well lately is, I don't know if you're familiar with Amy's Baking Company, Bakery, Boutique, and Bistro in Scottsdale, Arizona. Gordon Ramsay has a show where he goes out and he tries to help restaurateurs up their game, increase their level of customer service. Found these 2 people to be absolutely impossible to work with. First time ever in the history of the show, he stormed off, said, I don't want to work with you guys. This led to a social media tirade by the 2 of them. The 2 chefs took the Facebook page, took the LinkedIn page, called their customers punks, told them they didn't know what they were doing, said that God was on their side. I mean, everything that you don't want to do, just look up Amy's Bakery Company and don't do anything like that. So not only did these guys put themselves open to a lawsuit, they lost a lot of customers, and their brand is truly suffering because of it.
Before you go to the next one, just how you mentioned Target and even the most sophisticated and professional companies, I didn't tell Jennifer this before this, but some of those policies that we went through that were found to be unlawful were Target's policies. So it's tough out there. Even sophisticated businesses who are working really hard to get it right sometimes get it wrong.
Absolutely, absolutely.
Okay.
And that's why you want to pick a strategy. You want to plan it out, figure out what you're going to do, and you want to stick to it. In the case of the post that Lauren's got in his hand right there, what our goal was to set this company up as the subject matter expert for New Tampa and Wesley Chapel only. Even though he sells real estate statewide, even though he sells throughout Tampa Bay, his main concentration of business is New Tampa, Wesley Chapel. So you'll see posts in there about nonprofit events that are going on in the area. It goes a little bit beyond the whole realtor realm, but it works for him because he's establishing himself as a good neighbor, as a good citizen. That's the strategy. We're sticking to it, and he's had great results so far. Again, generate a month's worth of posts. Make sure that the people who need to see it, see it. If you have a legal team on your behalf, run them by them. Don't let them take all of the personality out of the post, but make sure that you're in compliance with the law. Brand messaging is very, very important. For instance, going back to Target, Target knows how it defines itself. It has a messaging style guide that people can refer to. So their social media department knows exactly what they can and cannot say at any one given moment. So that eliminates any surprises. And again, here's where that whole number of administrators comes in. You want to make sure that whoever is on your page knows what your voice is, know what they can and cannot say, where they get their information, and how often they post. So always plan in advance, and you'll never have any Amy's Baking Company kind of issues. Comments, positive and negative. A couple of our clients are restaurant clients, and that from time to time we have to deal with a comment on Yelp or TravelAdvisor. Respond to it immediately. Don't wait. Don't hesitate. Offer them their money back. Make sure that you have taken to heart what their comment was, even if it's the dumbest thing you've ever heard. Particularly for a chef, it's very, very hard to get negative comments about their craft. But you have to be able to say, we're so sorry the experience was bad. What can we do to make it up to you? How about a free dinner? How about your money back? What is it we can do to make the situation better? And they instantly diffuse the situation by doing that. Another example of someone who did not diffuse it was the whole Chick-fil-A Dan Cathy information, where he posted on Facebook that they were a Christian-based organization and that they believed in the sanctity of a man and woman being married. Well, it created a firestorm on Facebook of people who did not agree with this decision, and in a split country, 50% agree and 50% disagree. And for a company like Chick-fil-A, they need everybody who wants a chicken sandwich to feel they can go in and get one. So that was very, very hurtful to their brand. They later came out with a peacemaking statement that kind of smoothed things over a little bit. They're still struggling just a bit. But then you got Monsanto. CEO Hugh Grant posted on Facebook that he thought the whole movement toward organic was revert elitism. That the people who were eating organic, locally sustained foods were just absolutely wrong about their belief, and they were just being elitist, and they were out to hurt Monsanto. Well, all that did was fuel the fire on the social media circles, that now it's this no GMO foods. There's other Facebook page devoted just to this whole reversed elitism concept. So not only did they take his comment and comment on it, they ran with it, and they're running it into the ground. And if you look at any kind of non-modified GMO food sites, there's a bunch of them now, and they never were there before Hugh had to open his mouth and say something like that. So it can be quick when someone makes a post like that, and to date, Monsanto has not responded to it, so the fire continues.
I just want to make one comment reference to the
Sure.
Premark. That's one of the distributors that had a retailer, or is a retailer clothing design that one of its distributors had a floor on the factory, one of the factory in, is it Daku in Bangladesh, that collapsed. And the reason why I'm bringing up this example is because it kind of brings up my lawyer head in me that says, oh, you're admitting to liability in your social media pages? What? To Jennifer's reacting to it, claiming responsibility and being responsible as a branding mechanism.
Right.
And both are important. I will say in this case, they initially, I think within 24 hours or a very short time after the incident, they had a update on their Facebook page that basically acknowledged that yes, we are one of our retailers or distributors was up there. We're going to look into it. We'll try to do the right thing. They got 500 likes right away, and then the comments started. And then as the news started continuing, people were using the Facebook page as a way to vent, and the comments started getting negative. However, as with your advice, they stayed consistent with their message, and then later they posted again, staying on brand, keeping, reaffirming their commitment to be responsible, and for that one they got all likes again, or mostly all likes. So
Right.
That's an example of where being consistent, even if in the short run doesn't look good, you go forward. I'm still have my lawyer mind is you know, what you say on Facebook probably will get into the court, so,
Yeah,
Yeah.
yeah, it's a fine line. I
but
mean,
it's
another
good.
example of that is Chrysler had a young intern that was managing parts of their Facebook page, believe it or not. And what they posted one day was that nobody in Detroit knows how to blank drive. Now, this is coming from Chrysler corporate, right? So what did Chrysler do? They fired the employee, number one. Number two, they created a whole ad campaign called Imported from Detroit. So that it came out on the Super Bowl, it came out everywhere. So that whole Imported from Detroit arose from one stupid comment from somebody playing around on their social media pages. Now they have a social media strategy in place. They have a social media team that conducts it. They don't let just anybody who might have 10 minutes log on to Facebook and say whatever they feel like.
Oh, is that the last one?
I think that's it.
Okay. So with this, if anyone wants more information or if you'd like a copy of the PowerPoint slides, I have binder full of references, any of the references that are listed in there, the FINRA guidelines, the FTC guidelines, any information, just let me know and I'll email it to you. A lot of times when you give presentations, they say you're supposed to give a subtle call to action. Well, I'm not going to be subtle. Here's the very loud call to action. Go back and look at your policies and see if you have any questions or concerns about it. Come up with a social media plan. If you plan on being engaged in social media, come up with a plan. And if you found this to be helpful, and if you know of any organization or another group of people that would like us to present it, let us know, and we'd be interested in doing that.